Hi, I'm Fahey, a registered patent attorney and trademark attorney with the Plus IP firm. And this is going to be a brief video on the patent application process and the process for getting a patent in the United States. So first off, I typically recommend a prior art search or a patent search and a patentability opinion to determine whether or not you'd be able to get a patent before you file an application. A prior art search or a patent search is essentially a search of databases for patents or patent application publications worldwide that could affect your ability to get a patent on the invention. In some cases, you may not want to file a patent application if the probability of obtaining a patent is low. So something to think about. So let's say you've done the search and the opinion and you want to file a patent application. A patent attorney can actually draft the application, and most people will hire patent attorneys to do that. The main part, or most important part of a patent application is actually the claims section. The claims section describes the main elements of the invention. It's kind of like the nucleus or the heart of a patent application. The claims section really is meant to explain what is the inventive features and cover the scope of the invention. So you want to make sure it's done properly so that you have the broadest protection possible. So let's say you've drafted your application and you're ready to file the application. It's filed and then it is examined initially by an initial examination team. They review that certain requirements are met, and then eventually it will go to an examining attorney. An examining attorney at the USPTO is actually also a registered patent attorney. The examining attorney will examine the application, and then the examining attorney will conduct his or her own search to see what else is out there. So essentially they're doing their own search, their own patent search, to see what other publications are out there that existed before you filed your patent application. After the USPTO conducts their own search, the examining attorney will potentially issue what's called an office action. An office action are reasons why the patent application may not be allowed or may not be granted a patent. In the US, we have three main rejections that we typically see that I'm going to discuss here today. And the first one is a 101 rejection. A 101 rejection is based on a statute which is 35 USC 101. And that basically says that whether or not it's patentable subject matter. You typically see these in software type inventions or some biotech inventions. And in short, in software, if you get a 101 rejection, what it means is the examiner is saying that your invention is too abstract. Stated differently, in the US, you can't patent laws of nature and logic, certain types of logic. So for example, the simple algorithm, if X then Y, you're not going to be able to get a patent on that. It has to have something more. It would be considered too abstract. So there are certain things that we, as patent attorneys, we do to get around those rejections in some cases. So that's the 101 rejection. The second type of rejection you get is a 102 rejection. That's based upon 35 USC 102. 102 rejection basically is a rejection saying that all the elements of your invention, every single claim element that you have in your patent claims, is actually found in another reference that the examining attorney found in his or her search. So all elements of the invention is described in another application or another patent that was existing before you filed your application. That's called a 102 rejection or an anticipation in rejection. What that means is all elements of your invention were anticipated in a single reference. The most common rejection you're going to see is a 103 rejection. A 103 rejection is based upon the statute 35 USC 103. In that rejection, an examining attorney can actually combine multiple references to say that that combination of references combined teaches all elements of your invention. That's an obvious rejection. The 103 rejection goes something like this. The combination of reference A and reference B would have been obvious, so therefore the combination of these two references teach all elements of your invention, and thus your invention is not patentable. Definitely the most common type of rejection you're typically going to get, and there are really good ways to get around that. And you can argue that the combination of the references would render one of the references inoperable. You could potentially argue that the combination of references would actually frustrate the purpose of the actual main reference. There's a few ways you can get around that. You can certainly amend the application or amend the claims to include additional references. So we have many different ways to get around that in our toolbox. So let's say you get a 103 rejection. An attorney can respond to the office action. Typically, you can respond within 3 months, and then you can pay additional fees to respond for up to 3 more months. So you can actually respond up to 6 months if you pay some fees. Now, let's say you respond and the examining attorney rejects it again. On the second rejection, typically it's known as a final rejection, but the final rejection is not final. You could actually respond in several different ways to the examining attorney to a final rejection. I'm not going to go through those right now, but there are several different ways to respond to a final rejection. Or you can actually appeal the decision to the Patent Trial and Appeal Board. That's the PTAB. That's basically a board that oversees the USPTO examiners. So to see whether or not they're doing their job correctly, if you think there's been an error or if the examining attorney got it wrong, you can appeal to the PTAB. That's one of the ways you can actually respond to a final office action. So let's say you get around the rejections. The next step in the process is the examining attorney will issue a notice of allowance. A notice of allowance gives reasons why your invention is patentable. And then after you receive a notice of allowance, you are required as the applicant to pay an issue fee. The issue fee is paid to the government, and then after the issue fee is paid, the examining attorney and the USPTO will actually issue the patent. That typically takes about 11 weeks. So if you have any questions, let us know. But that's generally the process of filing an application in the United States Patent and Trademark Office. If you go without paying expedited fees, it typically takes between 15 to 24 months to get a patent. If you expedite it, which you can in the United States by paying a fee, of course, you're supposed to get it back within a year. So if you have any questions about the patent application process, please let us know, and I hope you enjoyed the video and learned something.